Thanks for staying with us. The Attorney General of the Federation, Lateef Fagbemi, has asked the police to transfer the case file of protesters arraigned on the 1st of November at the Federal High Court in Abuja, but that's before Justice Obiora Egwuatu. The AGF in the press statement says there are some issues his office will need to look into to make an informed decision. Celestina Area tells us more about this.
On 1st November 2024, the Nigerian police arraigned 119 protesters before the Federal High Court in Abuja. Out of the 119, 76 were believed to be minors, while 43 were above 18 years. They were arrested on 3rd August in various parts of the country: Abuja, Kano, Kaduna, Zaria, Katsina, Gombe, and Jos. They were arraigned before Justice Obiora Egwuatu on a 10-count charge of terrorism, attempt to overthrow the government, and mutiny over their participation in the nationwide protest which took place on 1st to 10th August 2024. They looked pale, starved, and exhausted. 4 out of the alleged minors slumped in court when docked to take their plea. These startled Justice Egwuatu and forced him to rise abruptly. Lawyers for the defendants scrambled to obtain snacks for the suspects to boost their energy levels.
12, 13, 14 years old.
Shortly after, the court reconvened. Justice Egwuatu struck out the names of the 4 defendants who slumped due to ill health, after which the remaining defendants pleaded not guilty to the charges when it was read to them. They were subsequently granted bail in the sum of 10 million naira each, with 2 sureties in like sum. The judge held that one of the sureties must be a level 15 civil servant and the other a parent of the suspect. The sureties must make available to the court a means of identification with a verified address, letter of last promotion, and letter of appointment. The defendants were remanded at the Postal Center, Kuje, pending the perfection of their bail conditions.
We will strive and do our best to perfect these conditions. But if we cannot meet those conditions, we will come back to the courts and seek for a variation.
Counsel for the prosecution disagrees with counsel to the defendants that they are minors.
These boys that we brought to the court today, all of them are adults. Most of them are married men. None of them is a minor. Some of them are university graduates. The small kids you are seeing here, they came with some of their parents to come and greet their loved ones.
The Attorney General of the Federation, Lateef Fagbemi, has asked that the case file be sent to his office. The AGF in the press statement says that there are some issues his office will need to look into regarding the matter to enable him make an informed decision. He says the case was adjourned to January 2025 and it is not within his powers to vary the order of court remanding the defendant in detention center and the adjournment. However, he has instructed the Director of Public Prosecution of the Federation to immediately begin a process for consideration of the court to bring the adjournment to an earlier date. Section 174, subsection 2B and C of the Constitution empowers the Attorney General to take over and continue any such criminal proceedings that may have been instituted by any other authority or person, and C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by him or any other authority or persons. But there are some controversies across various jurisdictions on the contextual definition of a juvenile or a child. The Child Rights Act 2003 defines a child as a person under the age of 18 years. However, Section 2 of the Children and Young Persons Act states that a child means a person under the age of 14 years. Article 1 of the Convention on the Rights of Children defines the holder of rights under the Third Convention as every human being below the age of 18 years.